In December of 2013, the Non-Human Rights Project filed 3 lawsuits in the state of New York. And those lawsuits were on behalf of 4 chimpanzees who were in the state of New York, who were in cages in the state of New York. And we asked that the court recognize them as persons within the meaning of a common law writ of habeas corpus. And we asked that the judge, let me see, maybe if I stand here. We asked that the judge order them to be released as the judge would order any human being who was being held in a cage to be released and then sent to a chimpanzee sanctuary. And what I want to do over the next 45 minutes or so is talk to you about how it is we came to do that, why we chose the state of New York, why we used the common law writ of habeas corpus, why we used the chimpanzees instead of any other animal, why we did it in December of 2013. And then after I explain that, I'll talk to you, which is going to take quite a while, then I'll talk to you about what it is we're doing there, what cases we have filed, what's happening to them. In fact, even Tommy's case is still alive, which you might not know. He might get out yet. We're not finished with this at all. And then what we have planned. So for me, personally, the story begins in 1980 when I was a lot younger than I am right now. And at that time I read a book by Peter Singer that talked about the way we treated non-human animals. And I was a young lawyer at that time. And I was persuaded almost immediately that for the reasons that I had become a lawyer, which was reasons of social justice, that those reasons held and were even more important for non-human animals. I hadn't realized the scale of the amount of injury that we inflicted on them, how bad it was, how many there were. I just really had never thought about it. And as soon as I read that book, I almost immediately decided that I would try to become an animal protection lawyer. And that's what I did. In English, we might say, I turned on a dime. One day, I hadn't thought about it. I read the book, and the next day, I came to my law partner and said, I now want to represent the interests of non-human animals. And you can imagine he was not all that excited, but that's what I decided to do, and that's what I did. And over the next 5 years, I began to do that. And the following year, I saw that an organization called Attorneys for Animal Rights, which is now called the Animal Legal Defense Fund out of California, was having a meeting in New York City, and they wanted to move from a small organization in California to a nationwide organization. And in the year between the time that I read Peter Singer's book and the time I read about that and went to New York City, I thought I was the only lawyer in the entire world who was interested in doing this. And there in New York City in 1981, I met a whole lot of lawyers, perhaps 10 of them or 12 of them, who were interested from all over the United States. And we then formed Attorneys for Animal Rights at that time, and within 2 years or 3 years, I was the president of the organization. And we were very small, and we used to sit around at the beginning saying, we all understand the scope of the problem. What is it that we can do, and how can we do it to change the way in which we treat non-human animals? And we all began to file certain kinds of lawsuits in our private practices through the Attorneys for Animal Rights, and we lost a lot of them. In fact, we may have lost all of them, but we certainly lost a lot of them. And by 1985, I was persuaded that there was a systemic problem, there was a structural problem, in that non-human animals in the United States, and as far as I know, everywhere, still were treated as legal things. Now, once I began to understand that, then I knew what it was that I needed to attack. And I began to come up with the metaphor of this thick, high legal wall. And on one side of this wall are, I'll start with this side, are legal persons. Now, a legal person is simply an entity that has the capacity for one or more legal rights. Those are legal persons. On the other side of this wall are legal things. And legal things don't have the capacity for legal rights. They are invisible to judges in their own right. Their value is only seen as instrumental value, really, for legal persons. They are essentially the slaves of legal persons, whether it's your automobile or your washing machine or a non-human animal. On the other side, persons are the masters of the world. We are all persons here, but it was important to understand, and it took me a while to understand it, that being a person and being a human being are not only not the same thing today, but they've never been the same thing. They've never been synonyms for each other. So, for hundreds of years, there were many human beings who were on this side of the wall, who were legal things. Women for some purposes, children for purposes, some purposes, slaves for virtually all purposes. And a great deal of civil rights activity, both at the national and international level over the last centuries, involved the process of breaking through that wall and beginning to feed these human beings slowly, women, children, slaves, and beginning to no longer have them characterized as things who don't have the capacity for any rights, but to have them be characterized as persons. This is something that we try to explain to the judges in which we go in front of immediately. Because like so many of us, the judges, by the way, am I speaking too fast? Okay, because once I start talking, then I get excited and I start speaking faster. So I'll try to control myself. So when we speak to the judges, we want to disabuse them of the notion that a person and a human being are synonymous. Because our client, after all, is going to be a non-human animal. And if a judge believes that a person and a human being are synonymous, then it'll be very easy to rule against us. They'll just see that our non-human animal plaintiff is not a human being and therefore is the thing and therefore lacks the capacity for any rights at all, including the one that we are asking. So we point out to the judge that for hundreds of years, many human beings were also legal things. And now they've been moved through an opening in that wall, and now they're legal persons. There aren't any more slaves. But we also point out that there are many entities who are not human beings who are legal persons, who have the capacity for one or more rights. There's corporations, ships, partnerships. States themselves are legal persons who may have rights. And then we also, since I'm operating in a common law country, and I will get to that in one moment, that we look at sometimes at the cases that are decided by other common law, that is, those jurisdictions that are English-speaking, whose laws derive from England, the way the laws of the United States do, that they have passed, they have numerous cases that have been decided in which a non-human was seen to be a person. And we point out a case from India in 1920s in which a Hindu idol was said to be a legal person, in which a mosque was a legal person. In 2000, the Supreme Court of India held that the holy books of the Sikh religion was a legal person. And perhaps most interestingly, in 2012, the indigenous peoples of New Zealand and the Crown agreed that a certain river was a legal person who owned its own riverbed. So what we try to explain to the judges is that personhood, those entities who have the capacity for rights, those entities who count, when you're trying to decide who should be a person, who should not, it's a matter of public policy and a matter of principle. It's not a matter of biology. And it never has been a matter of biology. It just so happens now that we are at the point where all of the human beings have passed from being a legal thing through that hole in the legal wall to being a legal person. But it's just a temporary place. Right now, we're now in the process now of moving it further along. That there are non-human animals who are still on that side, who have every right. If you're in a rational legal system, which I try to persuade the courts we are in a rational legal system, that they too now should also begin passing through that hole in the wall and start to become legal persons who have certain sorts of legal rights. So I knew that was going to be hard because all non-human animals indeed are legal things. So how is it that we're going to begin to attack the legal thinghood of all non-human animals? Well, I mentioned that I litigate in a common law jurisdiction, a jurisdiction that derives its law from England. Now, there are great differences between a common law and a civil law jurisdiction. And sometimes we in the common law can scarcely understand what's going on in a civil law jurisdiction. And I know that many people in a civil law jurisdiction can scarcely believe what goes on in a common law court. To simplify it enormously, a civil law jurisdiction makes its law through its parliaments. And judges don't make law. Parliaments make law. Well, that's not what happens in a common law jurisdiction. To a significant degree it is. Our Congress, our legislatures, they make law through statutes. But the judges in a common law jurisdiction also make law. And they do it through the process of deciding cases. And when you decide cases over years or decades or centuries, as the law begins to accrue, principles emerge, and those principles are just as much law as if a parliament had enacted a statute. So, while everyone around us in the United States had been thinking for years and years that the only way that we could ever change the law involving non-human animals was to go to our legislatures or at the federal level to the Congress, we in the Non-Human Rights Project understood that there was another way, and that's to utilize the duty of common law judges to make the law under certain circumstances. When experience says that the old law no longer works, when scientific progress comes down so that judges understand that a law that was based upon science that is now known not to be true should no longer be the law. When morals evolve, morals change, and they do all the time. Now, in the fight, which happened in England over a long period of time, but it's been settled now for a number of centuries, when there's a conflict between a legislature and a judge or a court, the legislature will generally win out. So that does not take away the responsibility of a common law judge, though, to change the common law, that is the law that judges make, when it's necessary to do so. So, for example, if I am riding my bicycle down the street and I run into someone, or someone's driving a car and they run over me, I can sue them for negligence. I'm sure you can do that in Holland as well. That's not something that a legislature ever said. In the English-speaking, in the common law countries, that accrued over a period of centuries. The whole law of negligence is something that continues to evolve within the courts. Same thing for a contract. If I sign a contract with someone and they breach the contract, there's not a statute that says I can sue them for breach of contract. Under the common law, the law that judges have made and how the law of contract has evolved over the centuries, that's what allows me to sue. Now, if the legislatures don't like the way the judges are evolving negligence law or evolving contract law, they can step in and say, no, we want you to do this or we want you to do that, and the courts will do what the legislatures say. But there are numerous areas in which the legislatures have never legislated and may never do so. And the courts are just as powerful as the legislatures are. So one of those areas are generally the area of persons. In the United States, the fact that a non-human animal is not a person, but is a thing, is something that the judges decided a long time ago. There's not statutes that say who's going to be a person, who's not going to be a person, generally. What happens is that the judges themselves over the years have said that human beings are now persons, but more significantly for us, all non-human animals are things. They're property. They can be owned and controlled by persons. And so, understanding that, we decided to begin to try to attack this legal thinghood of all non-human animals, all of them being on this side of that wall, by trying to persuade courts as a matter of justice that at least some non-human animals should now begin moving through that wall from being a legal thing to being a legal person. Now that's an idea that I came up with along with a colleague of mine named David Favor about 1985. And we began to recognize that that might be a way that we can move. At that time, 1985, it was a different time. There was no party for the animals anywhere. No, the whole idea would have seemed ludicrous. I had times in the early 1980s when I walked into a courtroom and other lawyers would start barking at me. They don't bark at me anymore, but they did at some times. The whole idea of animal rights or even animal protection was in its infancy. The idea of animal rights actually has turned within the United States, and I'm sure here, really into a misnomer. As far as the media is concerned, wherever I see it, anyone who's interested in any aspect of the welfare of a non-human animal is called an animal rights activist. Animal rights is seen as what I would call animal protection, animal welfare. When we in the Non-Human Rights Project talk about animal rights, we mean it in a technical way. We mean that our plaintiff has a legal right, is a legal person. And if we're talking about anything else, then we talk about animal protection, animal welfare. When I'm not litigating on behalf of the Non-Human Rights Project, I am litigating on behalf of the welfare of non-human animals. I've probably saved the lives of perhaps 150 dogs over the last 30 years who've been killed that I come in and try to stop it. And I've succeeded almost every single time. Probably 4 or 5 of my dogs have been executed. And that's because their owners were impossible to deal with. I couldn't persuade the judges to give the owners a second chance, or usually sometimes a 6th chance. And so the dogs, not the owners, would be executed. So I do animal welfare cases, but I understand that's what they are. The Non-Human Rights Project is doing something very different, which is animal rights, truly animal rights. Now, how long was this going to take? Well, in 1985, as I said, there was no such thing really as true animal rights, or even an animal rights movement. It was just beginning in its first decade. So at that point, I thought that it would take about 30 years of work before I didn't imagine there would be a Non-Human Rights Project in 1985, but before I or anyone I was working with would be able to file a lawsuit anywhere in the United States that had some kind of a reasonable chance of winning. I could have filed a lawsuit that I would have lost really fast anytime I wanted, but that's not what we were into. I was interested in. We wanted to figure out how it is that we can begin to move animals through that hole that we wanted to open in the wall. So I figured it would take 30 years. It turned out I was way off. It only took 28 years. So how is it that we began? Well, first of all, we understood that we had to begin educating our brothers and sisters in the law, judges, professors, other lawyers. We had to make them understand that what we were doing was serious and that we were invoking values and principles that they invoked all the time as well. So there had to be law school classes. I was asked by the Vermont Law School in 1990 to teach a class in animal rights law. And at that time, I think there was one other person, though I'm not 100% sure who that was, but I think that I was the second person to be asked ever to teach a course in animal rights law. And so I've now taught that for 24 summers in Vermont. Even as late as 2000, there still weren't more than 10 or 15 people teaching any kind of animal law. I teach animal rights law, other people teach animal protection law, but there weren't more than 10 or 15 of us throughout the entire United States. As I speak now, there's probably 150 different law schools that have some kind, within the United States alone, that have some kind of a class in either animal protection, animal welfare, animal rights. And in fact, there are now universities, Lewis and Clark, where I'll be in 3 weeks, where I teach the animal rights jurisprudence. They have a master's degree in law. I just came from teaching at the Autonomous University in Barcelona. There is a master's program there in animal law. I believe there's a doctorate in Basel. And so the whole idea of animal law or animal rights began to take root, because once you're teaching in law schools, first of all, judges realize that you're teaching in law schools, so do professors, but also you're beginning to teach a generation of law students. The ones I taught when they were 25 years old at the Vermont Law School are now 49 years old. I don't know how that happened, but when I added up, that's what happened. So they're 49. And some of them are going to become judges. And I remember telling them, when you're a judge and they wheel me into the courtroom to argue, just remember what we were talking about here. And some of them almost certainly are. In 2000, even more importantly, I think, for the animal rights movement, as far as the law goes, was that Harvard Law School asked me to teach the first class in animal rights law. And it helps to teach a course at Harvard Law School because it's at least an indication that you're not insane. So it's the imprimatur of Harvard Law School says, well, if it's good enough to be taught at Harvard Law School, then it makes it harder for other law schools, the other 200 law schools within the United States, to say, we don't want to teach a class like that because there's no intellectual content to it, or there's no substance to it. We say, well, Harvard Law School teaches it, so I think you might be able to think about teaching it too. And now, as I said, there's 150 schools that do that. So besides teaching, then we also had to begin writing, because we lawyers want to see written arguments. We want to read books. We want to read law review articles. I don't know if you have them, law review articles in Holland, but in the United States, every law school has at least one so-called law review where students publish journals and they write articles about interesting legal points, and they ask for articles from the broader professional community as well. So we wanted to begin, and I certainly began writing a series of law review articles setting out the ideas as to why a non-human animal should have a legal right. And I wrote them from about 1992 till about 1998. And somewhere around 1998, I realized that nobody was reading them. And what I really needed to do was to put them in trade books. Because even the judges or the other lawyers, I think, would probably be more likely to read a trade book about it, than an obscure law review article. It turned out that that was true. So in 1998, then I began work on a book that derived from my series of articles that turned into the book called Rattling the Cage Toward Legal Rights for Animals, which was published as a trade book. And then at that point, it came out almost the exact time that I began to teach at Harvard Law School. And also at the exact time in which Peter Singer was appointed to a post at Princeton. And this began to get the idea, certainly within the United States, that something important was going on, that there was this discipline that was kind of gelling, that was kind of coming together, that that might be interesting, that might be important. So I could see that myself, and understanding that, in 1996, I formed a nonprofit corporation called, or charitable corporation called, the Center for the Expansion of Fundamental Rights, which later was changed to the Nonhuman Rights Project, with the purpose of being able to have that organization be involved in education, but also to be the litigating arm that eventually lawsuits were going to be brought through the Center for the Expansion of Fundamental Rights. And so I began to write these books, and then after I wrote Rattling the Cage, I wrote Drawing the Line, which kind of modified and expanded upon the ideas of why a non-human animal should have rights. And then I was walking through Westminster Abbey in 2003, and I went to Poets' Corner, and I saw a huge plaque there that was dedicated to a man named Granville Sharp, who I had written about in Rattling the Cage for about a page, because he had been involved in a case called Somerset versus Stewart that I had talked about, where a black slave had actually been freed through the legal process. And I began to read this plaque and saw that one of the most important things he'd ever done was to be responsible for bringing this case, Somerset versus Stewart, in which slavery was essentially abolished. Human slavery was abolished in England. And so I thought, I want to write a book about that, and I want to use it as a blueprint for what the Non-Human Rights Project was going to do. And that's what I did. And I told the story of this boy, 8-year-old black boy named James Somerset, who was kidnapped from West Africa, and he survived the Middle Passage and was sold to a man, a Scottish businessman named Charles Stewart in Virginia in the 1740s. Charles Stewart then became the highest-ranking British customs official in North America. And he would go all up the eastern seaboard of North America, from the Carolinas into Massachusetts, and he would bring James Somerset with him. And by the late 1760s, James Somerset was now in his mid-20s and had been traveling with Charles Stewart for more than 20 years. Charles Stewart then asked for leave to move to London because his health is failing, and he brings James Somerset with him. Well, James Somerset, when he got to London, decided that he no longer wished to be a slave and he wanted to escape. There were 15,000 slaves in England at the time. And what he did, he decided that he was going to escape, and the first thing he did was to get himself baptized, because he believed that no Christian would enslave another Christian, even though all he had to do was look at the streets of London, and he could see many Christians who were enslaving other Christians. So he did that. But another thing that being baptized got him was that they got him a set of godparents. And in 18th century England, if you were a black person who got baptized, the most important thing about godparents was that they were there to help you escape. And that's what he did. 2 years later, he escaped, and he had a confrontation with Charles Stewart, and he said something that enraged Charles Stewart, and then he disappeared into London. And at that time, it was the largest city in the world, and Charles Stewart was so angry that he hired slave catchers to find James Somerset and not bring him back to Charles Stewart, but to bring him to a ship, the Anne and Mary, that was anchored in London Harbor, and they were to chain him to the deck, and they were to sail him to Jamaica, where he would be sold in the slave markets, and he would then be doomed to harvest sugarcane for the 3 to 5 years that a black man who was harvesting sugarcane had to live. Now, when that happened, 2.5 months later, it took them that long to find him. When they did, when the slave catchers caught up with him, they then took him to the Anne and Mary, and they chained him to the deck, and the ship was going to set sail for Jamaica, and most likely, his godparents went to Lord Mansfield, who was the Chief Justice of the Court of King's Bench, an immensely powerful man in 18th century London, and they asked that he issue a common law writ of habeas corpus. Now, again, common law, as opposed to a statute, remember, common law is the law that judges make, while they could have asked for a statutory writ of habeas corpus, because that existed as well. But that's what the Parliament made. Instead, they asked for a common law writ of habeas corpus, which meant they were saying, we want you to use the law of habeas corpus as judges in England have been evolving it over the centuries, and we want you to apply it to a black slave, James Somerset, and order him freed. Now, when they went in to see Lord Mansfield, by the way, Granville Sharp was also behind this, and Granville Sharp had been bringing a series of cases in front of Lord Mansfield for the last 5 or 6 years because he had decided that slavery was going to be abolished in England, and Lord Mansfield was going to do it, though he did not bring that up with Lord Mansfield, but that's what he decided. And the cases that he had brought were causing Lord Mansfield a great deal of anguish. Many of his friends had slaves. He had a slave, but that was his grandniece, which is a whole other story. And he, just that morning, had thrown out or finished the last slave-related case that was in front of him. And by coincidence, 6 hours later, James Somerset's godparents come to him and say, we want you to issue a common law writ of habeas corpus on behalf of this slave. Now, instantly they put Lord Mansfield into the same position that the Non-Human Rights Project had now put 4 judges in the state of New York. And we do it on purpose. What happened was that Lord Mansfield had to decide, could he even issue a common law writ of habeas corpus? A writ of habeas corpus of any kind can only be issued on behalf of a person. It may not be issued on behalf of a thing. Now they're coming in and saying that he is a person, and you ought to find that he's a person, and you should issue the writ of habeas corpus. So if Lord Mansfield had believed that James Somerset was a thing and always must be a thing, he would not have issued it, and the world would be a different place. If he's positive that Lord James Somerset is a person, then he will issue it. But why would he think that? It had never happened before. So what I think Lord Mansfield did was exactly what we've now asked 4 judges in the state of New York to do, which is, you don't need to find that he's a person. What you need to do is find that, what Lord Mansfield needed to do was to find that James Somerset might be a person. He could be a person. And you should issue the writ of habeas corpus, get him off of the ship before it sets sail out of the jurisdiction of English law, bring him in front of you, and have a hearing as to whether or not he was actually a person. So Lord Mansfield could have ended it right there, but he didn't. And that's one of the reasons why he's one of the greatest judges who's ever spoken English, is that he issued the common law writ of habeas corpus. James Somerset was taken off the ship. The captain was ordered to bring Somerset in, and James Somerset was then bailed. He was allowed to go free after paying a certain amount of money, which his godparents probably did. And then over the next 6 months, this extraordinary series of hearings occurred in England between November 1771 and May of 1772, which was, as I said, extraordinary for several reasons. One was that there were 8 lawyers involved. This was at a time in England when almost every case involved no lawyers at all, or sometimes there was 1 lawyer. To have 8 involved meant that everyone understood this was an extraordinarily important case. 5 of them appeared on behalf of James Somerset, 3 on behalf of the master, Charles Stuart. And it also lasted on and off for 7 months. This was at a time in England when the average felony jury trial lasted 10 minutes, including jury deliberations. So the fact that you'd have 8 lawyers and over 7 months was extraordinary. Finally, in May of 1772, Lord Mansfield wanted the parties to settle the case. He did not want to make a ruling. Everybody by that time on both sides understood that this is what we today would call a test case. Can there be slavery in England or not? Human slavery in England or not? And they refused to do it. And what Lord Mansfield then did is say, well then, he said it in Latin, he said, well then, let justice be done, though the heavens may fall. And that's the name of my book, Though the Heavens May Fall. And On June 22nd, just the other day, June 22nd, 1772, he then said that slavery was so odious, and he used the word odious, and I want to make sure you understand in English, odious is very, very, very bad. So slavery is so odious that the common law, which is supposed to only support good things, will not allow it, and therefore he ordered James Somerset freed. And that essentially ended the institution of slavery within England. It would be another 50 years before it was ended in the English colonies, but that essentially ended it there. And that was through, again, a common law writ of habeas corpus. So the reason I wrote the book was I wanted to tell the story so that judges and professors and lawyers and anyone else interested in it could understand how it had been used in a courtroom and on behalf of a legal thing. There it was a black slave. For us, it was going to be some other kind of entity, other kind of slave. It'd be a non-human slave. So by 2007, I was done. I'd sent an email out saying, essentially, I've been working on this for 22 years. I've been theorizing, writing, teaching about it. Now we're ready to go. We're ready to begin filing lawsuits. It would take us another 6 years before we're able to do that. And why would it do that? Well, first of all, we had to figure out where were we going to file this lawsuit. Because in the United States, we have 50 states, the District of Columbia, Puerto Rico, the Virgin Islands, the entire federal law system. So there's 54, 55 different jurisdictions, and they're all different. And some of them are extraordinarily different. And so we then came up with 50 or 60 different legal issues that we had to then research through all 50 states. So we had to really come up with we had to make basically 3,000 separate decisions as to how each state dealt with all of these issues. And it took us more than 5 years to do that. By 2011, I was supervising 70 people, 70 volunteers of all kinds, lawyers, law students, law professors, and others, sociologists, mathematicians, psychologists. We're all working on these kinds of issues. And on Easter Sunday in 2013, my legal working group had been meeting in New York City about every 3 months, every 4 months for the last 5 years. We decided that the state in which we were meeting at a hotel in Times Square in New York City, that was the state that we thought, overall, looking at everything, would be the most favorable, or at least the least hostile to us, based on our analysis of New York law. Now, only one of us was a member of the bar of the state of New York, and that wasn't me. So I wanted to argue the case, and so the New York member of the Nonhuman Rights Project would eventually go into court every time we've gone into court, and now I think we've been in court 8 or 9 times. She asked that I be admitted, what's called pro hoc vice, for the purpose of arguing the case in front of this court, and the judges have always allowed that. So we decided that there was the state of New York. Now, what animal were we going to choose? Usually lawyers do this the other way around. I'm sitting in my office, somebody comes in with a problem, and it usually has to do with something that occurred in the state or the city that I'm in, and we file suit there. We're doing this backwards. First, we're choosing the jurisdiction, and then we're going to find our plaintiff. So beginning in 2000, and when I wrote Rattling the Cage, and then the second case, Drawing the Line, I had looked at a whole series of non-human animals and talked about what kind of extraordinary beings they were. And I talked about all 4 species of great apes: orangutans, gorillas, bonobos, chimpanzees, both species of elephants, African and Asian, as well as species of cetaceans, orcas, dolphins, whales. And they were extraordinarily intelligent, but more than that, I argued that they were autonomous beings, that they were intelligent enough, or their minds were complex enough that they were autonomous and self-determining beings. And the reason that we argued that I argued it then, and then applied it in the state of New York specifically, was because it was clear that under the common law of New York, all the courts of New York had for quite some time showed that autonomy and self-determination was perhaps the supreme common law value in that jurisdiction. So we found cases, for example, where you might have a person who was in a hospital and he decides that he doesn't want to be fed intravenously anymore, or he won't accept life-saving surgery, or he won't take medications so that if he takes it, it will kill him. If he doesn't take it, it will kill him. And the courts there decided that it was so important to protect the autonomy and self-determination of these human beings that they would not interfere and they would allow that person to die. So he might say, I'd rather die than have this surgery. The court will say, well, then we'll let you die. And they would say it in ways which made you realize that the courts valued their autonomy and self-determination even more than they valued that person's life. So you don't get any stronger value than something that you value even more than someone's life. So that was something I realized early on was a value that the common law certainly held, and that's why I talked about these animals, the apes, the elephants, the cetaceans. I would go visit all the scientists who who'd studied them for years, dozens and dozens of them. In fact, I think in one of the books I thanked almost 70 scientists who had helped me. Now, I have a degree in chemistry, so it helped me be able to read scientific journals. It helped me to be able to understand their scientific work, and they would then go and I could go to their laboratories or visit them in Africa, and they would talk to me about the work that they did so that I could understand what they were doing. And I thought, okay, these animals appear to me to be autonomous and self-determining animals. Their lives are not ruled by instinct. Their lives are ruled by the way that they rule themselves, the way that my life is not ruled by instinct. It's ruled, I do what I want to do. I'm self-determining. Well, so is a chimpanzee, so is an elephant, so is an orca. And that fit in very nicely with the idea of a writ of habeas corpus. Because now a writ of habeas corpus means that somebody is detaining somebody else, and when you go in and ask for a writ of habeas corpus, you're asking the judge to order the jailer, the detainer, to bring in the detained person, this happened in the Somerset case, and give a legally sufficient reason why you can do that. Now, what sort of values was the writ of habeas corpus protecting? Well, it's protecting the autonomy of the imprisoned person. After all, when somebody commits a serious crime, we put them in prison. If it's very serious, we put them in prison. Why do we do that? It's a way of punishing them. It takes away their autonomy, their ability to self-determine. Somebody else is going to be making all the decisions for them from now on. That's how we punish a human being who commits a serious crime. So someone who is detaining somebody else is also taking away their autonomy and self-determination. So that's why I thought that the combination of an autonomous and self-determining being who's being imprisoned, that's why we would be able to file a writ of habeas corpus or seek a writ of habeas corpus, because a writ of habeas corpus is protecting the autonomy and self-determination that a human, or at least some non-humans, have. That, I thought, was a good place to begin. And that's where we did begin, because we could have found many causes of action. In fact, we're prepared to file other lawsuits with other causes of action, as we lawyers would say. But instead, the writ of habeas corpus is really a beautiful thing. And it's beautiful for human beings who are imprisoned against their will, and it should be just as beautiful for non-human animals who are. It's just that judges need to get the idea that it might be applicable beyond a human being. And I had a judge ask me 3 weeks ago about autonomy, and I'm saying that the writ of habeas corpus doesn't protect human beings, it protects their autonomy. And so it should protect autonomy wherever it might be found. A chimpanzee doesn't matter, an orca doesn't matter, an elephant doesn't matter. It's their autonomy that is protected. That's why a writ of habeas corpus is completely appropriate. So we then began to look for, I had our science committee then looked for every ape, every elephant, and every cetacean in the state of New York. And they had to report back to us and tell us where they all were, identify every one of them. And we spent 2 days going through them all. We'd go online and say, what about, where's this chimpanzee being held on our computer? Where's this elephant being held? And we finally decided that there were 2 chimpanzees being held in a crummy little roadside zoo in Catskill, New York, named Reba and Merlin. And those were going to be our 2 first plaintiffs. We're going to file a common law writ of habeas corpus on behalf of them. 2 weeks later, I flew there, it's too small to fly to. I flew to New York City and drove there. And I went in and I found to this crummy little roadside zoo, and I found 1 chimpanzee. And that was Merlin. And I learned that Reba had died about the time we were deciding that she would be one of our first plaintiffs. So we kept going, planning our lawsuit throughout 2013, because we had decided that on December 2nd, 2013, that was the day that we would file our first lawsuits. So in the end of September 2013, I sent my executive director back to that zoo to check on Merlin, and he was not there. And we learned he had died the night before. As you can imagine, on many grounds, that upset us. So what we did is decide that we felt a moral obligation to go in and find every chimpanzee we could in the state of New York and seek a writ of habeas corpus on behalf of all of them, no matter how many of them there were. We had no idea really how many there were for sure. So we eventually, by going through our computers and talking to people, we thought that there might be 6 of them in the state of New York. It turned out that one of them, who was supposed to be in a zoo, was not in the zoo. The person who did the website for the zoo did not know the difference between a chimpanzee and a monkey. And they exhibited monkeys, but they had a picture of a chimpanzee. So that brought us down to 5. So then I found them. We found Tommy. I believe that Tommy was going to be in this used trailer lot in a little town. You could miss it, and I did miss it 3 times before I could find it, in Gloversville, New York. And so we went there, and through various ways, we were able to come face to face with Tommy. And I knew he was there. I knew he was in a cage. I knew where he was. Then we drove to Niagara Falls, New York, where we believed that there were 2 chimpanzees named Kiko and Charlie who were being kept in a cement storefront in Niagara Falls, along with 29 monkeys and 13 exotic birds. And while I went there, I talked to the person, and I wasn't able to see Charlie and Kiko, but from the conversation we had, by the way, he was holding a monkey when I talked to him, and he gave me the monkey to hold while I was talking to him. But in the conversation we had while I was holding a spider monkey, I realized that Kiko and Charlie were indeed back there in the dark. I could not see them. Then we also believed that 2 chimpanzees named Hercules and Leo were indeed being used for not even biomedical research. They were being used at Stony Brook University in eastern New York in order to try to understand how it was that the common ancestor of chimpanzees and humans, who had bent legs, how they evolved straight legs. So these 5 juveniles, from the age of 3 to the age of 8, they were being kept in cages so that these scientists could understand why we had evolved straight legs instead of bent legs. Now, again, I have a science degree myself, but I thought that this was not right. So we then, on December 2nd, 2013, we then went and filed suit in a small court outside of Gloversville, New York. We sought our common law writ of habeas corpus on behalf of, for the first time, a chimpanzee. The judge, to put it mildly, was surprised, but he allowed us to argue. We thought that when we put all our papers in And these papers, by the way, were about this thick. And they were that thick because, remember, if we're arguing that autonomy is a sufficient ground for giving you a right to habeas corpus, to bodily liberty that's protected by a writ of habeas corpus, now we have to prove that our chimpanzees are autonomous. We had spent months and months identifying scientists from around the world who we thought were expert in the area of the cognitive abilities of chimpanzees. And 9 of them filed affidavits for us that were more than 100 pages. They came from Japan, they came from Sweden, Germany, England, Scotland, and the United States. And so we filed this stack of papers, and then we were immediately brought in front of the judge. We thought that the judge was just going to say, denied, go away. We thought that would happen all 3 times. And to our astonishment, it didn't happen. When he immediately said, come into the courtroom. He didn't even read our papers. He said, come into the courtroom. And you can see from the transcript, if you wish to go on our website, nonhumanrights.org, you can see the transcript of every single word that's been said in all of our hearings that we have. And you can see what he said. And he allowed us to argue. We went back and forth. And he finally said, he said, basically, I love chimpanzees. I'm going to do everything I can to get Tommy out of there, but I'm not going to issue a writ of habeas corpus because he's not a person. And so we said, thank you, and we appealed. Then we went to Kiko. Charlie was now, remember, there were Kiko and Charlie. Charlie was now dead. He had died just in the 2 months before we could file the suit. So there were now 4 chimpanzees in New York. And we went and we did the exact same thing. That judge was very clear to us. He also gave us a hearing, to our astonishment again. And he said, at the end of the hearing, that I'm not going to be the first to make this leap of faith. We said, we understand. We appealed. Then we went to Long Island, where Hercules and Leo were, and that judge did what we thought all the judges were going to do. We put the papers in, they came out, denied, go away. So we appealed. Now, when we appealed, the judge in the appellate court in Hercules and Leo's case threw our case out without even hearing us. They said we didn't even have the right to appeal. Well, we knew that we did have the right to appeal because that was one of the reasons we had chosen the state of New York. But rather than spend the time and the money doing that, we said, when we finish these other 2 suits, we're going to come back and we're going to refile it, not there, but we're going to file it in another court. And one of the reasons we chose the state of New York was that you could do that. You could keep filing cases forever, again and again and again. So we said, fine, we're going to file case number 2. And another reason we chose the state of New York is that we could file it in front of any judge we wanted to. So we did not bring our next case in front of the judge who told us to go away. We then brought our next case in front of somebody else. But first, we had to appeal the case involving Tommy. And so the first time we had an appellate argument I argued in front of 5 judges in an appellate court in the United States in which I argued that a chimpanzee was a person for any purpose, but ours for the purpose of a writ of habeas corpus. We ended up losing that case on a ground that we thought was completely wrong, which is that the judge said in order to be a person, you have to not only be able to have rights, but you have to be able to exercise responsibilities and duties, and chimpanzees couldn't do that. And we, of course, thought, well, don't the judge have children? There's little persons running around all the time who can't exercise duties and responsibilities. But the judges have thought about that. In a footnote, they said, basically, this doesn't apply to human beings. So we thought that's not really rational, and so we tried to appeal. We then asked the highest court of the state of New York to appeal that, saying they completely misunderstand what personhood is. And for all that, we did that almost 4 months ago, and we've been waiting for that court to tell us whether they will accept the case. Beginning when I'm in Europe, beginning every day at 3 o'clock in the afternoon, I start obsessively checking my email to see whether the judges have ruled. We then I did the same thing with Kiko's case. I went to a different appellate court in Kiko's case, and they completely ignored the other 2 appellate courts. They had a third reason for throwing us out. They said, let me see, what did they say? There's so many reasons. I'll think about it in a second. Whatever it is, we didn't like it. And we appealed. I will remember it. I will, since I've written about it extensively. I don't know why, it just slipped my mind. I'll remember it. So when we lost on that case, and I will remember it, why, we then asked that, we went to the highest court of the state of New York again, and, oh, I know why, I know I would. They said that only someone who is part of a social contract could be a person. You know, okay, so we said to the appellate court, we say there is no such thing as a social contract, number one. Number two, we showed them cases where slaves were not members of a social contract, but they were eventually able to be persons. And then we showed them cases where the United States has been keeping these people in Guantanamo for the last 14 years, but they're entitled to a writ of habeas corpus. Not only are they not part of our social contract, but according to the government, they want to destroy our social contract. So what's this business about a social contract? So we asked the high court to then allow us to appeal to them, saying the social contract business was wrong. Again, I keep checking my phone. We haven't heard from them either. In the meantime, we then went back to Hercules and Leo's case, and now we filed them in Manhattan. And we could not pick a particular judge. We just brought it to the for some reason, the lowest court in New York is called the Supreme Court. So we went to the lowest court, went to the Manhattan Supreme Court, and they then just chose on a random basis the judge who would hear our case, named Barbara Jaffe. She then issued the writ of habeas corpus. Hallelujah. It wasn't, I don't want to, I don't want to get too technical, but let me explain just for 20 seconds. Under the habeas corpus statute that we're using in New York, which is a procedural statute only, a judge can do two things. They can issue a writ of habeas corpus, which means you who is imprisoning somebody, I want you in here, and I want you to bring the prisoner in here. Or you can issue an order to show cause, which means I want you in here, but you can leave the prisoner there where he is. So we asked the judge to issue the order to show cause under the habeas corpus statute because we saw no reason to ask for two chimpanzees to be brought into a courtroom in Manhattan. That's what the judge issued. She issued the order to show cause. So for the first time, we had surmounted the hurdle of having a judge like Lord Mansfield do the same thing as Lord Mansfield had done. And when confronted with the issue, could the chimpanzees be a person? Her response was, maybe so. And she issued the order to show cause. So on May 27th, not very long ago, we had this hour-and-a-half confrontation in the court that had, the press was there, you know, the TV cameras were there, the courtroom was filled, and we had the fight that I had been picking for the last 30 years. And the Attorney General of New York was representing the State University, which was even better. So the judge, if you want to go to our website, look at what the judge was saying. She was eminently fair. We realized that we have a reasonable chance at actually winning this suit. And I remember turning to one of the people in the Nonhuman Rights Project as she's talking, saying, you know, we have a chance of winning. We just might win this. And we don't know. I keep looking at my phone for that. That's the third case. We're waiting for the decision of the court. Now, whatever happens, we will appeal her case to yet the fourth different appellate department in New York. And if we lose, we will then go to the Court of Appeals. But win or lose, just by getting that hearing, by having the court issue the order to show cause under the habeas corpus statute, it was the first time that a judge was doing anything but saying, this non-human animal is a thing who can't possibly have a legal right. The judge may not have said he's a person, but they said they might be persons. They may be persons. And we waited to see what the Attorney General would say. How would he respond to our 100 pages of affidavits? The answer was, he didn't respond to them at all. He just came in and made a whole series of procedural objections, which lawyers do, but not on this kind of a case, including, it shouldn't be in front of you, Judge. You need to stop this hearing and move it back to the county where they had kicked us out the year before. And she just ignored them. She ignored all of them and went right straight through. And we had you'll see, we had a terrific hearing. I have no idea what she's going to do, but we've passed that first hurdle. Now, we're not waiting around for all the judges to do whatever they're going to do in the state of New York. We've already begun working on our next case. This year, we will be filing a writ of habeas corpus on behalf of elephants in another state. And that's probably going to be sometime in the autumn. And it will help us if we've won some of the cases in the state of New York. But also, even if the Court of Appeals of the state of New York, the High Court, doesn't take our appeal, there's a reasonable chance that we will refile them. Because remember, we can file them again and again and again. And we'll look very, very carefully at why we lost before and then bring in affidavits that then reach that issue. So for example, the court that said you lose because every non-human animal cannot assume duties or responsibilities, there are really good scientists out there who will say, well, they do. They can assume duties and responsibilities. We'll refile again and see what they say this time. It'll be a little bit harder trying to figure out the issue of the social contract, but we'll try. So that's where we are now. That's where we're going. Not only are we moving state by state by state, animal by animal, and also cause of action by cause of action. We have other reasons throughout the 50 states, but we're also beginning to work with lawyers in other countries. So we're already working with lawyers in other countries, with groups of lawyers, in order to try to help them attain personhood and break through that wall in their countries as well. We're presently working with lawyers in England, in Spain, in Switzerland, in Argentina, in Australia, New Zealand. We'd love to work with lawyers in the Netherlands. Call me, send me an email. If I'll give you my card. We'd like to work with you. That doesn't mean we're going to tell you what to do. We have a lot of experience in our jurisdiction. We would then try to have you do what you think you need to do in your jurisdiction, but we would be able to bring whatever kind of expertise we can that will help you. Basically, we want to help you do your job in your country. So I have no idea what time it is. Yes, I do. I am so sorry. Thank you very much.